Hello everyone, I am Siddharth Bhatt, BCom LLB. Please welcome to my next video on Arbitration and Conciliation Act 1996. Now, why this act first came into being? Just to clear the basics, normally whenever a dispute arises, we usually presume to take it to the court, right? There a judge hears our case and after a couple of hearings, an order is passed. But the thing is, the court has a lot of pending cases before it, now most of which are not settled on time. So it results in a huge backlog of cases, and that's why to clear to remove some burden from the court system, they implemented this act in order to ensure alternate methods of resolving disputes. Essentially, there are three methods: arbitration, conciliation, and mediation. Now, regarding those terms and the further provisions of this act, let's move on now from now. So, even though this act was implemented only in 1996, just like every other law, this act does have a predecessor law which arose from the British times. First being the Arbitration Act of 1940. This was the original legislation. However, its scope compared to the present act was much more limited, and it was much more oriented towards the court system. And parties, they didn't have much of a say in how this arbitration and other alternate methods are to be conducted. Apparently, the authority still resided with the judicial officers. Then, from 45 years later, in 1985, the UN adopted a model called UNICITRAL. This model, uh, essentially, this was an international model which you could say it legitimized arbitration as a dispute resolution method. And because it was arbitration came to be adopted at an international level, it prompted our own country, India, to comprehensively reform the Arbitration Act, which had not been done so since the 1940. Then, about 11 years later, in 1996, the act was implemented, and this act incorporated the unicitral principles. So what did this act do? Apparently previously there was no distinguishing point between arbitration of any level, whether it be at the domestic or the international level. This act was the first to segregate those two types of arbitration. It provided clear provisions for international arbitration and for the arbitration at the domestic level as well. Okay, now moving ahead. Yes, so this act has continued to evolve further. From the first stage in 1996, when the present day act first came into being, in 2002, there was a technical amendment. Essentially, just like every act that we know of in law, which faces continuous amendments from time to time in accordance with what the situation requires, particularly if these acts are very old, like if they were in the 1960s, 50s, or even in colonial times. So the amendments are needed. So here also in 2002 there was an amendment. This was to bring the act more in line with the international standards, probably in respect of international arbitration. If in case one party was from abroad and the other from India, and in order to regulate arbitration at that level, apparently the amendments came. So what did this amendment do? One, it clarified what exactly would be the seat of arbitration, particularly at the international level. Then it also introduced some interim measures that would be taken in the course of arbitration before the final order was passed. Then in 2013 and 15, the major amendments came into being. One was it introduced an emergency arbitrator mechanism, meaning let's say if the arbitrator for some reason in the middle of the proceedings he decided not to go at it further, maybe he got tired of the proceedings or he was found somewhat unfit or disqualified to conduct it, then if the arbitration was such that it could not be postponed any further, that some emergency appointment was needed, Then that was brought in. Then this amendment also strengthened the confidentiality in arbitration. What the proceedings between the parties, unlike court proceedings, they are not public. This the nature, the proceedings, all the minutes of the proceedings, I should say, they are kept strictly private between the parties and the arbitrator. Then the enforceability of the then the arbitrators and then the enforceability of the order passed by the arbitrator and other provisions of the act, and the way in which arbitrators appointed, all of that was strengthened. Then from 2023 onwards till the present era, that is the present time, I should say, that there has been plenty of judicial interpretations have been done of this act, as is done of pretty much any act, mind you. So these interpretations of various cases and whatever judgments are passed on. So what happened was the courts, they are started to adopt a pro arbitration approach. It's been my personal experience when I attended especially family law cases in Bombay High Court. Occasionally the judges would ask the parties to take it to arbitration or mediation rather than wasting the court's time any further, in the hopes that the dispute resolution will be faster, also to take some of the burden of the court. Then of course online arbitration is now more of a trend. Rather than attending physically, you attend it through a digital medium, whether it be video conferencing or so on. Just like it has been just like virtual courts, which have been there since COVID-19 pandemic. Now moving ahead, what are the foundational principles and philosophy of the act? Now what are the principles of the act? Principle number one, see, the thing is, in the court system, the parties don't exactly have much of a say in how the proceedings are conducted. That is left entirely up to the court officers and to the presiding judge, and to a limited extent to the counsel for the parties. But here in arbitration, it is left entirely up to the parties as to how the proceedings are to be run. Essentially, the parties have the authority to appoint an arbitrator of their own choosing, and they can also decide how they are to conduct proceedings, how long is the proceeding to be conducted, and they could influence the final award to be decided by the arbitrator. Then here court intervention is minimal. Of course, nowadays, as I have said earlier, courts do ask the parties to take it to arbitration, but the courts do not normally intervene in the process. So not to mention, if there is a commercial agreement and it specifies an arbitration clause, the courts would normally have that clause enforced. They would not entertain the case any further, and they would ask the parties to take it to arbitration. Now, plus what happens with the arbitration is the courts also assist in evidence, as in if there is any evidence to be gathered by the parties in the arbitration, it could be submitted before the arbitrator, just like in any normal court, and on the basis of that a final award would be passed. Then what happens after the final award is passed? After the final award is passed, if any of the parties dissatisfied with the award, then they could simply appeal the case to the court itself, to the principal civil court of whatever jurisdiction the arbitration took place in, and the court has the power to review the award and possibly change it or confirm it or nullify it completely. Then confidentiality, like I said earlier, unlike court proceedings which are held in full public view, arbitration proceedings are strictly private. Whatever goes on between the parties and the arbitrator is strictly kept between themselves. No, the public, they can choose not to disclose the proceedings to the public. Then awards are final, as in it's not completely final. Most of the cases, especially in commercial contracts, when they impose an arbitration clause, they do say that it is final, but this is not strictly speaking true. You could appeal the award before a principal city civil court and further on if there was a sufficient ground to do so. Then How are arbitrators chosen? For there are the act has imposed very strict qualifications for appointing an arbitrator. The arbitrator has to be impartial on pretty much all counts. He cannot be he cannot be in any sort of relationship with any of the parties to the who is to the arbitration, not to, and also he cannot be not just whether it be business, personal, or whatever relationship. He has to be completely independent, and he has to be completely impartial. He should be in no position to be influenced in any manner whatsoever. Now, also arbitration is usually pretty short term. It takes place within a couple of months. As far as the act is concerned, it is supposed to take place within 6 to 12 months. I would say 12 months max, minimum 6 months. Let's compare it with how it is advantageous compared to litigation. Typically, it takes nearly 5 to 7 years in any court, sometimes even longer. There are cases I have heard where, especially in the lower courts, some cases are even pending from the 1980s or even from the British era. Imagine cases being pending for such a long time. That's how much backlog the courts have. And every time a proceeding is conducted, for as long as it goes, if you are if you are the unfortunate party to that suit, you have to pay the advocate's fees. Then the court also demands his fees, you have to pay them, and it goes on and on as the proceedings go on and on, which means you would be fruitlessly throwing away your money for something that might not happen for a long time, and even if it happens, it might not be to your satisfaction. Then there is no confidentiality in court proceedings. It's completed. It's there is if there is a cameraman in the court, he records all the proceedings. There is, even the general public is even allowed to sit in the court. So which means that if you want confidentiality, that confidentiality feature won't be available for you in a typical litigation. Then the judges in they are not, unless see, in arbitration, whenever they appoint an arbitrator, the parties first ascertain whether he has knowledge of the subject of the arbitration. But here in litigation, the parties cannot influence the judge's appointment in any manner. The judges are assigned cases by the court. So if a judge is deciding a particular case, he may not exactly be the judge the parties would want or would deem suitable. But of course, the parties have no choice in that. So again, there's the problem of not having a suitable judge for whatever case is going on. Then there is no finality to the court proceedings. Of course, there's no finality much to arbitration either, but most of the times arbitral awards are final. Parties don't usually dispute them. An arbitral award is accepted as full and final by the parties, but not so in the case of courts. Once a court conduct once a court finalizes its order and passes it, parties, if they are not satisfied, they typically take it up to the higher courts, whether it be to the sessions court or high courts and to the Supreme Court, all of which take years and would only result in a waste of time and money for both the parties involved, particularly for the aggrieved party, as in for the party against whom the appeal is passed. He is essentially dragged along without any choice of his own. So that's the problem. Okay, going ahead, what's the structure and scope of this act? There are first of all, that the preliminary provisions, sections 1 to 7, they talk about how the title, commencement, as in what essentially the starting of the act. Then how did the act begin and how does it apply? Then next part is arbitral agreement and what are the core rules on the agreement, what are the numbers and so on. Then there is a body called arbitral tribunal that is constituted often by a court, where parties are supposed, if they have a pre agreement on arbitration, they are supposed to take it to that arbitral tribunal in order for that dispute to be arbitrated. So what is the composition of that arbitral tribunal? How qualified and competent is that tribunal? That's also a provision in this act. Then next, how proceedings are conducted, whether there is any autonomy in the proceedings and so on. Then And if there is during the arbitration process, if one of the parties is not satisfied with how it is going, then applying to the court and the court granting interim mid-level measures, interim measures as in measures during the ongoing proceedings, then support the court gives and so on. Then afterwards it deals with the award being made during at the end of the proceedings. What form does the award take? How final is it? Whether it could be corrected and so on. Then what are last is what are the grounds for challenging and setting aside the award or modifying it, and how the award is to be enforced and so on. Okay, now moving ahead. What is a step-by-step process of arbitration? So number one is initiating the process. So now in every commercial contract there is an arbitration clause inserted in it, and that arbitration clause is usually considered as a separate agreement from the other parts of the agreement. So uh, if there's any dispute which arises, like if there's a breach of agreement on the part of one party, the other party, if it wants to take a step to arbitration, he first sends notice to the other party regarding that arbitration. Then the party to whom notice has been sent, he may reply. Now, how should the arbitration agreement be? It must be valid, as in it must be a clearly set out clause in an agreement, or better yet, a separate agreement attached to the main agreement. And it has to be necessarily in writing. Just like I said earlier, in law, almost everything is better off in writing, since that's the sort of evidence the court would definitely consider as true and right. Oral agreements cannot be easily proved. So what is the duration for initiating such arbitration proceedings? So once the aggrieved party sends a notice to the other party, the other party has to respond within maximum 30 days from the time he receives the notice. And if he responds, or if he doesn't respond, nevertheless, if he responds to that notice, then the arbitration process commences. Now, first step of commencement is, well, next step really, it is appointing an arbitrator. Now, the basic rule of Arbitration Act is the number of arbitrators appointed is not limited. It can be anywhere from 1, 3, even beyond that. But provided the number of arbitrators must not be an even number. That is, it must not be 2, 4, 6, 8 or something. It should be an odd number. Both parties could appoint one arbitrator, or if not, or if they are not happy with that, they can appoint an arbitrator of their own, but they also have to appoint a preceding arbitrator who will supervise over the other two. Then the appointment process is usually between a minimum 30 days, but it has to happen within 90 days max. Oh, and I should also say the parties have to first ascertain that the arbitrator appointed or arbitrators appointed, they are completely independent and impartial in any way whatsoever. They must not be in any sort of business or fiduciary, that is financial relationship or personal relationship for that matter, with any of the parties. Then there is a preliminary conference which takes place. So what happens is the tribunal, the arbitral tribunal before whom the case has been taken, it sets the rules for the way the procedure, that is the proceedings of the arbitration, are to be conducted. What is the language in which proceedings are to take place, and the timetable, as in at what date what proceedings would take place, what hearings would take place, and the minimum and maximum period within which the proceedings are to be completed. So the tribunal essentially sets broad rules, and the disputing parties, they can work within those rules. They can decide how the proceedings are to be conducted, how the arbitrator should conduct it, and so on. So what is the duration of this preliminary conference? Again, 90 days after the appointment of the arbitrator, and it has to, as in within 90 days the conference has to end, minimum. Maximum is 120 days. Then again, just like any normal court, the pleadings and evidence take place, as in both the parties plead their case before the arbitrator, just as they would in a court before the judge. Then they have to submit the proper documentation. Then any other related evidence which is admissible in a court of law would also be submissible before the arbitrator. Then they could, like just like in normal court, they would call on witnesses in their favor to testify in their favor, and also experts as well, those who are experts, people who are aware of the subject matter of the case. Then the pleadings have to be concluded within minimum 120 days and max 300 days, almost a year. Then obviously the hearings would also take place just like in normal court, oral hearings, then calling upon witnesses, examining and cross-examining them, then the closing submissions at the end of the arguments. Then the tribunal, it's the duty of the tribunal to ensure equal treatment of the parties and providing them all a fair opportunity of being heard. Again, the duration of all this is 300 to 400 days. Then award issuance. Then once the tribunal has heard all the and once the tribunal has had time to examine all the evidence and documents and consider all the pleadings that were made before the arbitrator by the parties and the testimonies of the witnesses and experts, then once it takes all of that into consideration, the tribunal would then pass a final award. This award is delivered. The reasons for why the award has been made the way it is has to be specified in the award document, and it is enforceable, the award. This again, the duration within which the award has to be made after the hearings is not after the hearing, but in the overall course it has to be within 400 days after the proceedings have commenced, and maximum period is 500 days. Then post award. Now obviously if there is any problem with the award which the parties feel they want to correct or something, then they can appeal, they can ask the arbitrator to correct the award in any way, or if the arbitrator is unwilling, they can appeal that award before any court, and the court would let's just say the court would do whatever it can to either, if the court would hear the parties, and on the basis of what it deems proper, it can either nullify the award, modify it, or even confirm it. Again, so essentially if it's not, so essentially even if it confirms it, if you take it to the court, it becomes as final as a court judgment. So what is the duration for this post award period is 500 days after the award, that is within it is a post award, so it's obviously 500 plus days. There is no time limit for this. So move ahead. So let's deal with sections 1 to 7, preliminary provisions and definitions. First of all, short title and commencement. This act was titled the Arbitration and Conciliation Act 1996, and it commenced on January 26, 1996. That's right. It commenced on Republic Day. Probably the choice of the Lok Sabha and Rajya Sabha where the order was passed, and probably the president chose it too. Then what is the extent of the territory to which this act applies? It applies throughout the whole territory of the Indian Union as specified by the Constitution. Until now, Jammu and Kashmir, before Article 370 was repealed, was exempt, but now the provisions of this act apply to J&K as well. Then before this act, the earlier act, Arbitration Act 1940. Now obviously with the implementation of this act, that act was fully repealed. So most of the provisions were also repealed, but they have saved some provisions from the earlier act and have incorporated them into this act. So this act also defines key terms such as arbitration agreement, award, who would be the parties to the suit, and court, as into what court you could possibly appeal the award if you do not like it, and others. Then this act guides statutory interpretation, as in formalized legal interpretation for arbitration, and essentially if you take the case for arbitration or conciliation with the mutual consent of the other party, the interpretation of all those proceedings and whatever happens, this act provides a base for that. Then this act sets foundation for, basically this act defines the procedure for conducting arbitration and how to enforce whatever comes out of arbitration. So now we come to sections 8 and 11, arbitration agreement and validity. So parties, they have an autonomy on governing law, as in let's say if your seat, essentially both the parties, they have the right to fully decide the seat of arbitration, which means they also have the right to decide what sort of law should be applicable for both agreement and substance, as in what sort of agreement should be put for arbitration and what should be the inner substance of that agreement. Essentially speaking, if they choose the seat of arbitration, they also choose the law of arbitration which is to be applicable to that agreement. If the parties are unable to come to an agreement regarding that seat of law, then the tribunal is what applies that seat if we have no choice. Then obviously if either the tribunal chooses, or if not the tribunal, let's say the parties themselves have managed to make a choice of seat of possible arbitration and the law applicable there, then the tribunal has no choice but to comply with the choice of the parties. Now arbitrators they act just like court officials in this case. That is, they can grant interim measures, that is they can grant injunctions, they can force the parties to do or not to do something, or they can ask for parties to provide specific performance against the parties to the agreement. They not against the parties, they can order the parties to provide specific performance, as in they can ask the defaulting party to do something for the aggrieved party if the aggrieved party made a case that performance was what was required, not any monetary compensation or anything. Then the arbitrators also have the right to have the assets of the defaulting party frozen. That's what asset preservation means. If in case they suspect that the defaulting party may try to dispose of the assets to get away from having to compensate the aggrieved party. Then the courts assist enforcement of interim orders, as in if for instance if the tribunal has passed some interim orders but feels that the parties may not be compliant or anything, then they can seek the orders of the court. They can go straight to the court having jurisdiction on over that seat, then ask the court for for assistance, as in orders from the court itself. It's to enforce the enforceability. But the arbitrators have to ensure that it doesn't prejudice the arbitration in any manner. Then before the arbitration starts, if the parties want urgent court relief, that is, if before the arbitration itself starts they want to apply for relief before the court, then they can do so. I mean, if they urgently require relief but before the arbitration itself begins, then the court can grant it to them. Now seat, once you've decided the seat of arbitration, the law of the place where that seat is situated, that's what defines the arbitral proceedings. Then the seat has to be explicitly specified by the parties. If you are in a business agreement and if you want to arbitrate, you got to have the seat specified, unless and until you want the tribunal to decide a seat for you which may not be suitable. Then for arbitration agreement has to be in written form only. You cannot, as oral arbitration agreements would be held invalid. As it is in any law, the arbitration agreement in any law, oral agreements are usually not held very highly as evidence. Written agreements are always safer, more secure. Written agreements could be anything, not just printed documents, but also emails, WhatsApp messages, and so on. So, the arbitration clauses, they as specified, it may refer to rules, even emails also. Emails or WhatsApp messages, if they specify the commercial agreement and the related arbitration agreement, that could also be regarded as valid evidence. So what are the highlights of this arbitration agreement validity? Number one, it has to be in written form. The parties have to be identified, as in the parties to the agreement, they have to be explicitly stated in the commercial agreement or arbitration agreement. Then what is the scope of the dispute which can be decided by arbitration? Which part of the commercial agreement cannot be arbitrated, which can be arbitrated? All that has to be specified. Then what sort of arbitrator is to be appointed? What should be his qualifications? And what sort of, all that has to be taken into account by the parties. Then all of this has to be done with mutual consent. So for example, let's say valid clauses. Number one, ICC rules sit in Delhi. What does this mean? It means that this agreement has to be decided on the basis of the rules set by the ICC with regards to arbitration. And should the agreement come to arbitration, it has to be done in Delhi, not anywhere else. Unilateral rules. This is especially in case of international arbitrations. If there is an international agreement and the parties are in dispute, then this clause specifies that it has to be done in accordance with the UN's rules and so on. Okay, now moving on. Sections 12 to 15. It deals with the appointment and qualifications of arbitrators. One is the appointment flow. The agree method. One is each party they appoint within 30 days. They have to appoint that one arbitrator who will preside over the proceedings. Or if they are not happy with only one arbitrator, they can appoint a separate arbitrator for themselves, and they also have to appoint. But however, a third arbitrator is also to be appointed to supervise the other two. So sometimes if there is a dispute here, also the court could step in, and if you want to dispute the appointment of a particular arbitrator, you can do so within 15 days of such appointment. Then what are the requirements for an arbitrator? Like specified earlier, the arbitrator has to be completely independent and impartial. He must not be in any sort of relationship, whether it be business, whether it be fiduciary or any personal relationship. Then the parties are also to ascertain just how competent the arbitrator is to decide the case, to conduct the proceedings, and his availability for that case. Then even during the proceedings, if an arbitrator is revealed to be incompetent, then he has to disclose it and so on. Then within 15, like I said, the appointment of an arbitrator could be challenged within 15 days from the date of appointment. Then if they dispute it before a court or before the arbitral tribunal itself, then the court or arbitral tribunal would take over the appointment of a suitable arbitrator. So on what grounds can he be removed? One is if he is incapable in any manner, whether it be mental incapability or qualification wise he is not capable, or if he does not act within time, or as in if he does not complete the proceedings within the time agreed, or if it turns out that during the course of proceedings it is revealed that he was in some sort of relationship with one of the parties or both the parties, or if that independence was lost during the proceedings, that then also his appointment is invalid. Then disclosure and acceptance. The arbitrator, it is his duty, if he is appointed, then prior to that appointment he has to disclose the circumstances which may affect his independence and impartiality, or if during the proceedings such circumstances happen, then he has to disclose it during the course of such proceedings. Again, number of arbitrators, the parties may agree on any number of arbitrators they want, provided it is not an even number. It cannot be 2, 4, 6, 8 or any other even number. It has to be either 1, then 3, then 5 and so on. There is no limit. Then appointment. Then parties here, unlike in court system, the parties have full authority and autonomy over what sort of arbitrator they precisely want. However, even here there are certain restrictions. They cannot just appoint any lay person as arbitrator. The parties while appointing arbitrator, they have to abide by the rules of the arbitral tribunal or whatever body governs arbitration, whether it be ICC, SIAC, LCIA. Then once they appointed the arbitrator, they also appoint a person who would preside over the arbitrator, the president, so to say. So However, what would happen if an arbitrator is not appointed within 30 days? They are unable to do so. Then the parties may ask the court to appoint an arbitrator for them, and the court can do so. So again, if the court does so, then the parties, they obviously they would have no choice but to accept that arbitrator, since he is court appointed, not by their own choice. Okay, now moving. Section 16 to 19, it governs jurisdiction and interim relief by arbitrators. Obviously, when it comes to jurisdiction, the arbitral tribunal has the power to rule on its own jurisdiction, as it can decide whether that case would be suitable to be decided by itself, or if it should just transfer the case to another suitable jurisdiction. So the scope of these sections is it determines jurisdiction, as in what sort of jurisdiction is best suited for a particular case and so on. Then what is the rationale for a suitable jurisdiction and so on. Then separability. Now even if a clause is put in an in a main commercial agreement, or if a separate paper or what Word document or whatever message also is attached to the main ones, says regarding arbitration, the arbitration agreement, whether it be a clause or whether it be a separate agreement, it is in any ways considered completely separate. Even if the main commercial agreement is rendered invalid because of time period expiring and so on, the arbitration agreement is not affected by that. The parties can still take the case to arbitration regardless of the validity of the main agreement, validity period I should say. Then what is the timing for filing objections? First of all, if you want to object regarding the suitable jurisdiction for that case, you have to raise that objection either before the first hearing happens or during the first hearing, not afterwards. Afterwards, you cannot do so. Uh, you have a narrow window of opportunity in that case, either before the proceeding start or during the first proceeding, not afterwards. Then under section 17, there is a party, the party may raise a plea such that they may contend that there was no arbitration agreement in the first place, or the arbitration agreement for some reason was invalid, or they may choose to take the dispute somewhere outside. Then if the parties happen to be dissatisfied with the arbitration proceedings, with the way it is being conducted or whatever relief measures the arbitrators have provided, they can of course I should say all of this is there, but most importantly, if you want to challenge the jurisdiction of that arbitral tribunal, and if the arbitral tribunal is not willing to entertain such challenge, you can take it straight to the court in which such you can take it straight away to the whatever court is situated within that jurisdiction. Then interim measures. This tribunal, just like any normal court, it may grant injunctions, it may freeze, as in it may order the other party to not do or do something in relief to the other party. Then if the situation is pretty urgent, if there is a possibility that the other party could get away with whatever crime, whatever breach they have committed, the tribunal could order for the assets of the defaulting party to be frozen until the proceedings are over. Then whatever evidence is submitted during the proceedings, the tribunal has the power to preserve that evidence for future references, whether it be for during the process of passing the final order or even much later on. Then interim relief granted by the court. If court, even before the arbitration begins, the court could grant interim relief on the request of the parties to the dispute, if the court believes that granting or interim relief is extremely suitable. Then there is a provision for emergency arbitrators. So essentially before the tribunal, if for some reason the arbitrator was disqualified from conducting arbitral proceedings further, then the parties could ensure that an arbitrator is appointed urgently, as in they could apply to the tribunal or court if they cannot do such urgent appointment themselves, and once the emergency arbitrator is appointed, he or she can uh, provide urgent relief. Essentially the tribunal, he can provide urgent relief to the aggrieved parties. Then what are the institutional rules? Again, even though the parties have the right to appoint their own arbitrators, that doesn't mean they can just appoint anybody, or they can just conduct proceedings however so they want without any restriction. Restrictions are there in any law, in almost all laws. So here also there are institutional restrictions. So especially when it comes to emergency arbitrators, that is, if the parties want to appoint arbitrators as quickly as possible, then these institutions, ICC, SIAC, LCIA, they provide such emergency arbitrators should the parties require it. Then there are several jurisdiction terms: ratione personae, materiae, ratione temporis, and so on. Then what is the distinction here? First of all, between tribunal and court in this case, what's the distinction? First of all, the tribunal itself decides the jurisdiction. So essentially, if the parties, they take the case to a tribunal, the tribunal itself decides whether it is perfectly fit to take on the case or not. Then court reviews, essentially if the tribunal is unable to decide, then they can take such case before the court for deciding the suitable jurisdiction. So essentially the court, however, does not take much of an interest in arbitration proceedings. It only takes interest in some very specific matters, such as the appropriate jurisdiction, or before the arbitration begins, if it wants to pass any interim orders or any urgent relief measures, then it has that window of opportunity, the court. The courts are usually not liable to interfere in arbitration proceedings once it starts. Okay, now moving. Section 20 to 25 talks about how the arbitral proceedings are conducted. So like I said earlier, the parties decide the place for themselves, the seat, and if the parties cannot do so, then the tribunal before whom that case has been filed decides the seat. So when does the proceeding start? It starts when the aggrieved party sends a notice to the defaulting party, and this notice must state what are the claims which the aggrieved party has against the offending party and what sort of relief it is seeking. And this notice also has to state what is the limitation period, that is, what is the minimum maximum period within which the other party has to respond. Or and if it does not respond, then what are the steps that the aggrieved party can and will take. Then language of the proceedings. The parties can agree on the language of the proceedings, that is, whether commercial language, business language, or let's say if the parties want language to be English, the proceedings can be conducted fully in English, or in case of domestic proceedings, in regional languages, Hindi, Marathi, Kannada, whatever, or any other regional language. Then it's not just one language. It is the arbitral proceedings are flexible enough that they can allow multiple languages also. Like, let's say if one party knows English and the other doesn't, then the other party could conduct the proceedings in his own or her native language. Then the tribunal must allow for interpreters and translations of those proceedings in the main language of the proceeding, whether it's English or Hindi or whatever. Then pleadings. So the party who is claiming any sort of relief from the aggrieved party, he needs to first file a statement of claim specifying the grounds for such claim, then the amount of such claim, and so on. Then obviously the the defendant party, he cannot take it lying down. So it is his right to file statement of defense, or plan a possible counter action or counter claim to the aggrieved party's claim. Then amendments of that process, if you want to amend your pleadings or whatever documents you submitted, though that is allowed provided you seek the tribunal's permission. You cannot do so on your own. Then if there are some changes which are happening way too late, like if you pleaded during the initial start of the proceedings and the proceedings are almost at the end and then you decide some changes, the tribunal has the full freedom to reject those changes, or if those changes they happen to be extremely prejudicial to the proceedings or to one party beyond any reason, then the tribunal may restrict such changes as well. Then hearings and written proceedings. First of all, the parties have the full liberty to agree on what sort of hearings should take place before an arbitrator, and if they cannot do so, the tribunal would decide otherwise. Then then the tribunal could conduct, then the tribunal also has the choice of deciding what kind of hearings would take place. Either way, if the parties agree on hearings, it is the final decision of the tribunal on what sort of hearings could take place, whether it be completely oral hearings, that is parties just argue among themselves using their mouth, or if not that, then the tribunal will decide that no, only written documents or other sort of evidence, whether it be emails or WhatsApp messages, only that would be admissible, or a combination of both. Then evidence and witnesses. The parties cannot just submit any sort of evidence. It should submit evidence which is admissible as per the rules set by the tribunal. And although there is some influence of the Code of Civil Procedure 1908 on this, again that again not all of the rules apply to this law. The arbitral proceedings, even though they are pretty similar to civil proceedings before a civil court, not all of those proceedings, not all of the provisions of the civil code are applicable to the arbitration proceedings. Consider it, it probably would have been earlier, but ever since this act came into being, the arbitral proceedings are all governed by this act only, not by the civil code of civil procedure. Then again, just like in any normal court, the parties have the right to call upon witnesses. The tribunal may examine those witnesses. Then if it can ask for the parties to submit affidavits regarding anything that has happened during the course of transactions between the parties. Then if there is any video evidence, like if for instance if anything happened during the transaction between the parties, anything related to the dispute, if one party took some incriminating video or something, that video could be submitted before the court as evidence. And if the arbitral tribunal is not able to decide the case on its own, it can seek the main court's assistance if required. Then what are the principles of this act, of the proceedings of this act, I should say? One is the parties have full autonomy, well, not full completely, it's subject to the arbitral tribunal and the other institutions governing arbitration, but nevertheless they do have some autonomy on how to conduct the proceedings, language of proceedings and so on, even on the number of arbitrators. Then the tribunal has its own discretion and how to intervene during the proceedings, or what sort of arbitrator is to be appointed, the number and so on. Then equal treatment to both the parties, no favor or bias in favor of or against one party. Then like I said earlier, the proceedings of this arbitration, they are strictly confidential, strictly secret. The parties have the full right not to allow disclosure of such proceedings before the public. Okay, now moving ahead, sections 26 to 28, it talks about expert determination and tribunal powers. So the tribunal has the full right to appoint an expert during the course of the arbitration proceedings. That is, this expert, he has the right to oversee the proceedings. Then if there are any technical issues which have arisen in the case of the proceeding which may invalidate the proceeding as such, he has to report to the tribunal on such issues, and he has to submit a written report regarding all that to the tribunal, and also provide a copy of such to the parties to the dispute. Now even though the arbitral tribunal appoints the expert, the parties have the full right to comment on expert terms, as in if the terms have, so essentially what is if the expert is appointed to provide some evidence before the tribunal, then the parties have the right to question the credibility of the witness and question him as to how exactly he managed to uh, establish such evidence and so on. Then during the hearings they can examine the methods by which such expert obtained the evidence and how did he manage to conduct such to come to such conclusions, and how did he manage to find uh, how did he manage to come to such findings. The parties have the full right to cross-examine the witness on that, just like they do in a normal court also. Then when it comes to taking evidence, if for some reason this case was happening before a court and the court to, ordered the parties to arbitration, then the tribunal could ask the court to redirect evidence submitted in that court earlier to the arbitral tribunal. Then this tribunal has very wide, as in it has vast powers to decide what sort of evidence it will take before itself, and it has also the power to investigate any suspicious act on behalf of the parties and so on. Then the tribunal may grant interim measures and request enforcement, as in during the case of the proceedings it would grant urgent measures mid proceedings to the parties if they need it, and it would require, it can order the enforcement of those measures as well. Nevertheless, there are limits to the arbitral tribunal's powers. Like these, it is bound by the written arbitral arbitration agreement between the parties. So if the parties have decided a seat of arbitration, the arbitral tribunal has to necessarily abide by that unless the question of jurisdiction comes. Then the overall the arbitral tribunal it does not work in a vacuum. It operates within the general framework of law, so it has to abide by the general law as well, and also it has to abide by public policy, whether it be morality and so on, as in what the public deems moral and legal. Then expert versus party experts. If the expert is appointed by the tribunal and the parties also call upon experts of their own during the proceedings, then the report of the part of the expert of the tribunal appointed expert, it is neutral. It takes into account both the parties' hearings and his own expertise, and he submits it. By contrast, the experts are appointed by the parties, it is obviously their natural duty to support the other party, support the party they appointed by providing the suitable evidence. So obviously the parties and the other party and the tribunal itself has the right, I should say the arbitrator himself has the right to cross-examine such a party appointed expert. Then costs. Obviously, when it comes to appointing its own expert, the expert who is responsible during the proceedings, the tribunal has the right to charge the expert fees from the parties to the arbitration, particularly the losing party. So and so on. Now moving on, sections 29 to 31, they deal with arbitral awards and decision making. So again, like I said earlier, the tribunal here, whatever sort of law the parties have agreed would be applicable to the act, the tribunal obviously applies only that law, unless the parties haven't agreed on the if then the tribunal will decide what sort of law would be applicable on its own. Then if the parties have not been able to decide the proper seat of arbitration, the tribunal before whom such parties may take the case, he has the right, the tribunal will appoint a seat of arbitration. It will apply, and not only that, if the part either way, when it comes to the seat of arbitration, whatever law is applicable to that seat, the arbitral tribunal will apply that law. Then if it is possible, if for especially this happens in terms of international arbitration where one party is from not from India and the other is from, so in case if the arbitral tribunal decides that Indian law is not sufficient, that it has to take into account foreign law, specifically the law of the country which the other party comes from. It can apply that law as well. Then if the parties decide to come to a mutual agreement, as in if they mutually agree on the terms of the arbitration, and if they mutually agree to settle terms, then the tribunal could supervise the mutual agreement and decide the award. Then when it comes to the seat of arbitration, if there are any mandatory rules relating to that seat, the tribunal cannot override that. The tribunal has to properly follow those rules. Then what is the authority of the tribunal? Then just like any normal court, even the tribunal has full authority to decide all facts and matters of law regarding the case. Then when it comes to liability of one or the other party and the amount of damages, again it has final authority on that. Then then when it comes to evidence submission, just like in any normal court, the tribunal sets, basically the tribunal decides the weight of the evidence submitted, which evidence is more important than the other, and it sets balance of probabilities, as in it takes into account opposing evidence of both parties and decides which is more likely to happen than the other. Then again the tribunal has vast, just like a normal court, it has vast discretion on the amount of importance attached to particular pieces of evidence, and when the witnesses are called upon and they give their testimony, how credible is their testimony, then what documents submitted, the way in which it chooses to interpret the document. Then if you want to if the tribunal wants the court to review the case for some reason, it has to specify the reasons why it is seeking a court review. Then when it comes to arbitration, if you have more than one arbitrator, like 3 or 5, then the majority rule applies here, just like in elections and all, where a party gets voted a majority. Here also majority rule applies. If the majority of the arbitrators agree on something, that's what applies. If there is any dissent among among parties or even among other arbitrators, that dissent is noted. Then what is the form of award? When the award is made, what should be specified in the award? Number 1, the award has to be completely written. Oral orders are not allowed. Then the date of the arbitral award has to be clearly specified in it. Then what was the seat of arbitration has to be specified. Then almost all of the arbitrators present have to sign the award, or if some arbitrators are not present, then the majority of the appointed arbitrators have to sign it. Then what are the contents of such award? What should the award contain? It should contain what claims the aggrieved party made, what were the actual facts of the case found out, then what sort of law was applicable to this case, or what are the applicable provisions, then what are the reasons for why this award was passed, and the signature of the arbitrators. Then what are the types of awards? One is final award. This award happens at the end of the proceedings when everything is said and done, and the parties, when the award is passed, the parties have to abide by it. It's not there's no way the award is changing unless you file a application for review with the tribunal or before the court. Then there has to be there could be a partial award. This is usually interim awards which are passed during the course of proceedings as urgent measures. Now this award it might be amended at the final stage. Then there is consent award. Consent award is if the parties themselves agree on the terms of the award, as in they have decided to settle the dispute amicably and by their own will. That sort of award incorporating the agreement between both parties could also be made. However, the flaw with this award is, unlike a normal arbitral award which could be disputed before a court, this sort of award passed by mutual consent is not disputable. This is completely final. So even if you as a party somehow decide later on that no, I do not like this award now, I want to dispute, then you can't, because you had earlier agreed to it. You cannot now dispute it. Then there is interim award, which I specified earlier. Award passed during the course of proceeding, which could be amended during the at the final stage. Then what is the importance of reasoning? This for essentially section 34, it facilitates section 34 as in the reasoning for why do you specify the reasons for the award. First of all, in order to validate the award itself. Secondly, if this is the case of international commercial arbitration, then if you want to enforce the award abroad where one party is situated, then the reasoning helps to enforce it. If any foreign court sees the arbitral award and sees the reasons, then they could decide that this award is enforceable after all. Then reasons also help to review the award should one of the parties desire it. They can look at the reasons and decide if this award is suitable or not. And if the reasons for the award are not properly put inside the award, or if it is just vague or something which is incomprehensible, that is that is the solid reason for setting aside that award entirely, since the tribunal has not bothered to specify why exactly the award is what it is or why it has been made. Okay, I'm moving. Sections 32-34 talks about termination of the proceedings, then cause and setting aside of awards. Well, after the final award is made, the proceedings come to a complete end. Proceedings for the unless and until you want to appeal the award, then you could start a new proceeding, but the old proceedings end. Then settlement, parties could settle amongst themselves if they want to. Then if for some reason the claimant feels that the arbitration is not suitable or that he is satisfied with the settlement, then he can withdraw the arbitration, or the tribunal can just choose to wash its hands clean of the proceedings for any reason whatsoever. Then what are the outcomes of settlement? So as in, like I said earlier, so once a mutual settlement has been made between the parties, arbitration rights, as in, let's say before you go to arbitration, if you decide to do any other, like say mediation or conciliation, those are mutual settlement proceedings, as in those proceedings end when the parties have mutually agreed upon something. So mutual agreement that extinguishes your right to have the case arbitrated. Then withdrawal rules. The one party who has made a claim against the other party, he can, for any reason to his satisfaction or any reason which he decides, he can withdraw that claim with the consent of the defaulting party, or if not defaulting party, if the defaulting party really wants to fight it and doesn't want the case withdrawn, then with the tribunal's permission. If you choose to withdraw your own claim, obviously the other party, the defaulting party, has no reason to continue the proceedings. The proceedings are fully terminated. Then, like I said earlier, tribunal itself may wash its hands clean of the proceeding. If for some reason it decides that the jurisdiction is not proper, or it doesn't have, the arbitrators appointed do not have the necessary ability or qualifications. Then fees for the arbitrator. The fees could be in the arbitration agreement itself. The arbitral fees may be decided, or if not in agreement, the tribunal itself may decide the fees of the arbitrators. Then advance. Sometimes the arbitral tribunal may ask for advance deposits prior to the commencement of the proceedings, specifically from the defaulting party, just in case the agreement goes just as a precautionary measure. Then cost allocation. Now this cost allocation differs. Most of the times it is the loser party which has to suffer the cost. whether it be the cost of the proceeding or cost demanded by the other party along with damages and so on. Then cost awards. Then as part of the award, the court may, or the arbitral tribunal may award the fees of the, essentially it may order the defaulting party or the loser party to pay the cost of the arbitrators, the fees of the counsel, as well as the fees payable to the experts who came to testify in the proceedings to the successful party as part of the award. Then the award could be set aside on very limited grounds, as in if during the proceedings there was any defect in the procedure, or if it violated the laws of public policy, as in if the policy of the party was such that the proceedings could be considered immoral. That is also one suitable ground for setting aside the award. Then what are the procedural grounds on which the award could be set aside? One is the agreement itself being invalid for any reason. Then the appointment of the arbitrators was not done properly. As in they did not vet his qualifications or his experience or anything. Then the jurisdiction is not proper, or the procedure itself is very defective, or the proceedings are such that one party is clearly being favored and the other ignored, or against the other party. That also is one ground. Then Indian public policy, again the award could be set aside on this matter only. The courts could interpret this on a very narrow basis. Essentially, public policy could be on the basis of what law says it is, or on generalized terms what is public policy as accepted by society at large. Then what is the time limit? So if you want to file an appeal against the award, you have to do so within 3 months from the date of the award, not afterwards. Then however, if you want to do so afterwards, court may, if you provide a sufficient cause to the court as to why you couldn't file the proceedings earlier, then the court may extend for such sufficient cause. Then burden and review scope. The applicant would bear the burden. Essentially, whoever is applying for arbitration, he would bear the vast majority burden of the proceedings, of the appeal. Then court would conduct a rather limited review of procedure. Essentially, if you are appealing against the award on the basis of faulty procedure or anti-public policy, then the court could conduct a rather limited review of those grounds. The merits, it doesn't take into account the exact merits of the case. So what are the common setting aside awards? One common being the agreement itself being invalid. Then appointment of arbitrator improper. All the factors in short that I said earlier. Then cost factors. The tribunal, while allocating cost, it considers the success of the other party, whether success was only partial, how was the conduct of the parties during the proceedings, how complex was the case, and so on, and how reasonable everything has been. Okay, now sections 35 to 43 talks about enforcement of the award and the court and the intervention of the court during the proceedings or afterwards. Then first of all, when it comes to domestic awards and awards, obviously in case of domestic awards, this happens within India, so it is fully enforceable as court judgment, as in it is as good as a court judgment, since the arbitral tribunal has been given full powers of a court. So whatever award they pass is fully as good as a court judgment. So however, what about foreign awards? Let's say if the seat of if the arbitration took place in America or England or any other foreign country, so would a award passed in those countries be applicable here? Now, as it turns out, there were two conventions passed which are applicable to that. One is the New York Convention and the Geneva Convention. The New York Convention makes it very clear that even foreign awards are enforceable in other countries. So, since our country, India, has also subscribed to that, so whatever awards passed outside, they are enforceable here as well if one of the parties is Indian. Then if for instance if the award is taken before a court for appeal, if those courts have jurisdiction or if they are located at the seat or place of arbitration, you could take this arbitral award to a civil court, and through civil execution or civil orders the award could be enforced. Again, the refusal is limited to the grounds that I specified earlier: improper, invalid agreement, then faulty procedure, then anti-public policy, and so on. Then what is the standard court enforcement process? First of all, you have to apply to the court with a certified copy of such award which is provided to you by the tribunal. Then the court would verify the award. It could hear if the other party he pleads against such appeal, then the court has to hear it, and then uh, it could execute the award. Then if you don't want to do arbitration at all, you could opt for conciliation. Conciliation is comparatively speaking voluntary. There is no written agreement here. Both the parties who would decide that instead of a formal court or arbitration proceeding, they can just try to settle amongst themselves without too much hassle. So how do you initiate this? You initiate the aggrieved party. He first sends out a notice to the other party regarding the conciliator, or if the court itself decides on conciliation, if the other parties haven't agreed upon a conciliator, court could appoint one for them. Then the agreement of the settlement during conciliation, it has to be in writing and it has to be signed by both the parties to the agreement. And this is as the conciliation agreement is as enforceable as a contract or arbitral award. As in, it is completely voluntary. If you want, you could literally have the conciliation agreement disputed before a court, and a court would simply throw it away, but otherwise it's as good as an arbitral award or a contract for that matter. So when does the conciliation end? It ends when both the parties have come to a mutual agreement. They have agreed upon the terms, common terms. If the and it also however ends when the party who had initiated the conciliation himself withdraws, or conciliator, he decides that there is no way forward with this. So what would be the fees of the conciliation? They would be as agreed between the parties, or if not parties, if this case was before a court, then whatever the court agrees. Then what is the practical steps for enforcement? One is you could apply to the court. You could apply to the court in case if you are not happy with the conciliation final ending. Then the court would check the authenticity, whether the conciliation was done properly or not. Then it could pass a summary order. After only a couple of hearings, you could just pass an order stating that a conciliation agreement could either be validated or set aside. Then if prior to all that, if the court still wants to do a proper hearing, it could do so with the usual procedure and all, and then it could either have the conciliation agreement executed or set aside. Okay, moving. There are several landmark cases which you can see here. One is Enercon versus Enercon Engineers versus Enercon India. So who are the parties here? One was Enercon Engineers and Industries Limited. This was a foreign company based in Germany, and Enercon India Limited. This is an Indian based company. So obviously this is international commercial arbitration. The judge was Justice Deepak Mishra. And where is this? This took place in the Supreme Court. So this case mainly revolved around separability. Essentially, this case, to put it shortly, this case took a very pro-arbitration posture. This case clearly decided that that arbitration is what is more suitable. So what was the dispute here? The dispute in this case related to technology transfer between the parties. Obviously, transfer of intellectual property and other machinery and equipment, strictly confidential between the parties. Then licensing also, the license to be provided to the other party for operating the wind equipment, windmills and all that. Then why was this the agreement challenged? It was challenged because it was believed that the agreement was executed without the appropriate government approval. So what was the key? So what did this first establish? Principle number one it established was that the arbitration agreement, even if there is just one simple clause specifying arbitration in the main agreement, that is clearly separate from the main contract. Whatever happens to the main contract, the arbitration clause would still apply even beyond the validity period. Then the other key principle was competence versus competence. So arbitrators, so what it established that arbitrators have the full right to decide their own jurisdiction. Even if the parties put down the seat of arbitration, the arbitrators have full discretion to decide whether they are suitable for this case. Then it also established, this case essentially established a pro-arbitration stance on the behalf of the Supreme Court itself. The court established that whenever arbitration took place, the court would not intervene, at least not completely. They could intervene occasionally if the circumstances required, but otherwise not so much. Then what was held in the final case? One was the court held that the arbitration clause in the agreement between two parties was enforceable. Arbitrators should decide their own jurisdiction. Then the courts went on to adopt a pro-arbitration stance. They essentially, this case kind of strengthened arbitration as an alternate dispute resolution method. And not to mention, when it comes to international commerce, it strengthened the international business by smoothing the international commercial arbitration process in case of disputes between a foreign party and an Indian party. Ahead, another landmark case, Hindustan Zinc Limited versus French Coke and Co Limited. This case was taken before the Supreme Court of India. It happened 4 years earlier, before the first case in 2010. Again, principles decided were competence versus competence and tribunal deference. So the parties were Hindustan Zinc. So the parties, okay, I will not specify the parties, is clearly specified here. Then what was the dispute? The dispute was relating to a supply of coal, and what were the terms of payment relating to such coal supply. So the defaulting party, he contested, apparently this case was taken before an arbitral tribunal, and the other respondent, he contested whether the tribunal had proper jurisdiction to respond to decide this case. So the one key principle which was decided was the parties don't exactly have the right to make the ultimate decision on the jurisdiction of the arbitrators. The arbitrators decide it for themselves. Then it also established the independence of the tribunal. The arbitrators, it was held, they could rule against either party, even if it is their own party, even if it's the same party which has appointed them, they could decide against that party also. Then the decisions of such arbitrators are clearly binding, unless for some reason those decisions were made in error without the arbitrators knowing the full facts or not considering the law properly and so on. Then this case also established the deference of courts to tribunal. It established that unless when it comes to jurisdiction, the court should not unnecessarily interfere in the jurisdiction proceedings. I mean, the courts, if for some reason a party disputes jurisdiction, the court, it cannot be up to the court to decide the jurisdiction unless and until it is transparently, very explicitly clear that the jurisdiction is clearly not applicable, right? The authority of the tribunal is is not in any way applicable to the case. Then, so the summary of the whole of what the case decided was the tribunal decides its own jurisdiction in a case. Decisions made by the arbitrators are binding unless it is beyond their authority. Then the courts have to defer to the tribunal. So what were the implications of this case? One was it gave tribunal the authority to proceed on a case without wasting the court's time or their own time. Then arbitration clauses in agreements are respected. As in the clause of an arbitration in a commercial agreement, they were validated. Then court intervention was reduced. Courts are not allowed to unnecessarily interfere. Then another landmark case, Bharat Aluminium Company versus Kaiser Aluminium. This took place 2 years after the earlier one. Again, the Supreme Court decided it. It focused on the grounds of pro-arbitration and narrow public policy. So, what was the dispute which this case was based on? One was technical services being performed by either parties. Then apparently this was an international agreement. Of course this was international because as you can see Kaiser means this was German. The Kaiser is an old term which was used to signify the title of the German emperor. So this clearly is a German party. So again, it's an international agreement. Apparently, some technical services have been performed by Kaiser with the other, and Bharat Aluminium had to pay royalties. So there had been some dispute regarding that. So yeah, that was the base of the case. So what was during the proceedings? What happened? Well, one was the party who was making the claim. He was awarded a relief by the tribunal. So the other party he decided to set aside so essentially in India itself, rather than taking the risk in Germany, apparently Kaiser Aluminium decided to set aside the award in India itself, alleging that it was anti-public policy. So what are the key legal principles? And one was the UN's unilateral principles. Since it's an international commercial arbitration, so the UN's model governs this case. Then public policy is only the very narrow definition applies here. Court intervention is not much court intervention would be here in arbitration, just like in earlier case. Then this case more importantly respected the autonomy of the parties to appoint their own arbitrators and conduct their own proceedings within whatever limited autonomies are allowed to them by the tribunal. So court reasoning, what was the reasoning of the court for its order? What did the court do here? One is it adopted a pro-arbitration approach just like in the earlier case. Then it decided that an arbitral award was essential. That way, if an arbitral award was made certain and it was fully enforceable, that way foreign parties would not have any hesitancy with dealing with our domestic parties. So the very concept of an arbitral award, a final arbitral award at the international level is what facilitated international commerce. So what was the practical impact of this case? One was it in concert with the rising trend of globalization, it has become ever more important to integrate our legal and other systems with the international ones. So it integrated Indian law with regard to arbitration with the international ones. Then enforceability of arbitral award was improved, and it gave a certainty and confidence to foreign businessmen to deal with ours. Okay, now moving ahead, another landmark case, Chloro Controls versus Rajesh Masrani. So this case happened a year after the earlier one. So what did this case deal with? It dealt with the scope and interpretation of arbitration clauses. So what was the key issue? The key issue was whatever arbitration clause they had made in the main contract or whatever arbitration agreement attached to this, did the dispute fall within that agreement? since what happened was the arbitration clause apparently that had been written in the agreement, it specified, it's essentially covered disputes arising out of or in relation to the main commercial agreement. So what did this agreement hold? It held that there is a broad language covers a wide range of issues, meaning the language of the arbitration agreement is not narrow, it's not very specific, it's broad, it is pretty much general. So it covers a wide range of disputes arising out of that agreement. So the reason this clause was interpreted so broadly, it was to give full effect to it, to ensure that there were no rest. One party did not gain an undue advantage over the otherwise somehow limiting the applicability of the clause. So what did the court preferred? The court clearly preferred the rather not the completely technical legal language, but the arbitration clause, the plain language it was written, that's what he preferred. So arbitrability, so what did it set us? So what did this case help to do? It first to help that any commercial matter, any matter which is arbitrable should be taken to arbitration, but some cases are not arbitrable. One is family law cases like divorce or any uh, dowry act cases or whatever. Those are not arbitrable. Those are either to be decided by the court, or in case of divorce cases often before a specific appointed parties in family courts. Then obviously criminal cases are not arbitrable. They are to be tried by a criminal court of law, no matter how long it takes. Then what is the practical guidance? First of all, to secure the jurisdiction of any tribunal to a case, the court emphasized on using broad wording, not specific narrow wording which could be advantageous to one party to the detriment of another. But so what the court said, the court has to say order that the arbitration clause should be drafted as arising out of or relating to, as in it should either arise out of that agreement or it has to be related to that agreement. That way it would not be confined to specific matters, but it would cover any matter arising out of that agreement. So what was the scope of this case? One is it specified what sort of language should be used in clause, subject matter of that clause, whether the just how broad would be the application of arbitrability to that case, then intention of the parties and so on. Then what is the impact? Impact number one, it clarified arbitration clause and essentially then how the clause should be interpreted, and essentially this case promoted arbitration as a premier ADR, as in alternate dispute resolution method. Moving ahead, so what have been the contemporary applications and recent developments? Like I said earlier, law is not static, it changes, it has to change in response to the changing circumstances in the broader world. So commercial agreements, when it comes to business supply, that is where customers, seller and buyers are themselves businesses, uh, as in you could say producers and wholesalers or wholesalers and retailers. Then when it comes to payment uh, for the goods or services, distribution of such goods services, then if two parties have entered into a joint venture or there are franchise disputes, these are all commercial disputes. So arbitration is very much preferred for, for the speed. Obviously arbitration disputes only take place within 6 months or max 12 months. So, and not to mention finality, except in very specific cases like I said, faulty procedure and anti-public policy, leaving those two behind, arbitral awards are usually final. So again, it prevents too much legal hassle. Then when it comes to construction and engineering, if for instance if there are construction delays or if the cost of construction has far exceeded what is agreeable or what was agreed upon between the parties, if there are any disputes such as defective construction material or structure was not properly done, and if there are contractor issues like between contractor and developer, there are disputes or uh, but the payment done is not proportionate to what was done. So again, these are all technical issues. Expert arbitrators who have a background in the construction arena, they are usually appointed for this. Then when it comes to technology and intellectual property, this usually leads to software, patents, then data privacy, e-commerce, disputes and so on. Again, the arbitrators being appointed are those who have a background in the technical world, as in the software world, IT world, all of this. Then when it comes to international commerce, that is foreign sales or foreign investment made or BIT disputes, again international commercial arbitration has been going. India, especially under the current government, has been rising as a hub for international arbitration. That said, we still have a long way to go. Most of the times they still do international arbitration in the Western countries or in nearby countries such as Singapore. So although we are rising as a hub, there is still miles to go. Then in 2015, like I said, there were reforms. One was it paved the way for the concept of emergency arbitrators should the parties want urgent relief but are not able to appoint an arbitrator of their own. Then it tightened the concept of secrecy, confidentiality of proceedings between parties. Then if the arbitration is to be conducted by an institution rather than parties themselves, it gave a recognition to that as well. Then 2020-23 there were some judicial shifts. Then as in the court started favoring arbitration more than litigation as the method to resolve disputes. Then just like in there were e-courts during the COVID pandemic, so there were digital proceedings for arbitration as well, that it started to be promoted. Then it started promoting fast track cases to be completed within only a couple of months, weeks even if that was preferable. Then institutional growth. SIAC, ICC, LCIA, NANI, they are all arbitral bodies. There they began to be given more importance. Then what are the contemporary trends? One is expedited arbitration. Parties want disputes to be resolved quickly. So they want arbitration which takes place as fast as possible. Then introduction of AI, like AI agreements made and so on, blockchain being uh, bitcoins and all that, that were paid, essentially fictional money, internet money, online money, so to say. Then diversity, ESG and hybrid procedures, so faster timelines, like I said. Then sustainability tech disputes have started to arising. Then India, like I said, has been rising as a hub. First of all, there are more skilled professionals when it comes to arbitration now. Not only that, not only just qualified in the legal field, but also on technical fields, IT field and so on. Essentially, Arbitration Act requires that arbitrators should not only be legally qualified, but they should also be qualified in respect to the field of the case they are deciding. Then there are cost advantages to India, like as you can see often in foreign countries, costs are usually much higher than in India. So people prefer India as an arbitration center due to lower expenses. Then seats in India, they have been increasing now ever since the reforms. Then arbitrators are also more specialized now as the requirements of the law state. So arbitration, to put it to summarize everything, arbitration is now expanding across the country. More and more courts, not just high courts, but even the district courts and all are now providing for arbitration as an alternate method, helping to ease the litigation burden. So what are the summary and key takeaways from this act? One is like stated earlier, parties have full freedom to design the arbitration. They have full freedom to appoint arbitrators to design how the arbitration is to be conducted. Second, court's role in arbitration is extremely limited to only providing to reviewing the awards or providing urgent relief measures before the arbitration starts. This is obviously faster than courts, where courts take years arbitration is supposed to happen only within months or max 1 year. Then proceedings are private. The parties have the full right to not allow the proceedings to become public. Then award is final, is not only enforceable like a normal court judgment, court order, but it's also final, except of course improper procedure or anti-public policy and so on. So yes, so that's it friends. Thank you for watching my latest video. Please subscribe to my, please do like this video if you can, and subscribe to my channel at Siddharth 4898. I thank you all for watching this video. Thank you. Have a thank you all for this watching this video. Thank you very much.